Okay, let's unpack this. Imagine a scenario, right? You've got a business, a transportation company in Utah, all resort group. It's failing, totally insolvent.
Like deep financial trouble.
But just before it completely collapses, the owners pull out about $145,000 of the company's money.
And not for, like, legitimate business expenses.
Exactly. They used it to pay their own personal federal income taxes.
Oof. Okay, so that money absolutely should have gone back into the pot for the company's creditors. You know, the suppliers, maybe lenders, people left holding the bag.
Right. But because the check was written to the IRS, the entity facing the lawsuit to get that money back, it isn't the owners who did the dodgy deal.
It's the U.S. government itself.
Precisely. So our mission today is a deep dive into this 2025 Supreme Court case, United States v. Miller. It's really a fascinating fight over that $145,000.
And what it tells us about the limits of bankruptcy law, specifically this power bankruptcy trustees have to claw back money that was improperly transferred out.
Especially when the government is the one who ended up with the cash.
Yeah, it highlights this huge tension, doesn't it? You've got the Bankruptcy Code on one side, designed to marshal assets for creditors, make things as fair as possible in a bad situation.
And on the other,
this ancient concept of sovereign immunity. Basically, the idea that you can't just sue the government unless it explicitly says you can.
So we're going to try and break this down, using straightforward language. This technical legal fight over $145,000 really defines who gets paid when big companies go under.
It really does. It has major implications.
Okay, so let's start with the trustee, David L. Miller. He's representing the bankruptcy estate of All Resort Group.
Right. His job is to find and recover assets for those creditors we mentioned.
And the facts are pretty stark. The company was broke. In 2014, two shareholders took about $145,000 of its money.
And paid their personal taxes with it. The company itself got absolutely nothing of value in return. Zero.
Which, under state law, Utah law in this case, looks like a textbook fraudulent transfer.
Exactly. So Miller, the trustee, sees this pretty clear trail of money going out improperly. He reaches for his main weapon.
The avoidance power. The clawback tool.
That's it. Specifically, he uses Section 544B of the Federal Bankruptcy Code.
Okay, Section 544B. Let's pause there because the mechanics of this are, well, everything in this case.
They really are. This federal power lets the trustee undo or avoid a transfer if, and this is the key part, it's voidable under applicable law by a creditor holding an unsecured claim.
Applicable law meaning state law, like that Utah fraudulent transfer statute.
Precisely. And that phrase, by a creditor holding an unsecured claim, creates this critical hurdle. It's called the actual creditor requirement.
Meaning the trustee can't just use this federal power on its own?
Nope. He has to first point to a real, actual creditor, someone the company owed money to, who could have sued under Utah law to void that $145,000 transfer outside of the bankruptcy process.
So the trustee basically inherits that creditor's rights. He steps into their shoes.
Exactly. He steps into their shoes. But, and this is crucial, he's also stuck with any limitations or defenses that creditor would have faced.
And that leads us straight to the government's big defense.
Sovereign immunity.
The government didn't really fight on whether the transfer looked fraudulent under Utah law, did they?
Not really, no.
Yeah.
They basically said, even if it was fraudulent, the trustee's claim under 544B fails anyway. Why?
Because no actual creditor could have successfully sued the U.S. government outside of bankruptcy to get that money back.
Right, because the government would just raise the shield of sovereign immunity.
Can you just quickly define sovereign immunity again, for anyone not familiar?
Sure. It's a fundamental legal doctrine. The U.S. government, as the sovereign, generally can't be sued in court unless Congress has passed a specific law that clearly waives that immunity for that type of lawsuit.
So if some random supplier to All Resort Group had tried to sue the IRS under Utah's fraud law,
the government's lawyers would immediately file a motion to dismiss based on sovereign immunity, and poof, the case closed. The court wouldn't even have jurisdiction to hear the merits.
Okay. But the trustee, Mr. Miller, and the lower courts, the bankruptcy court, the 10th Circuit Court of Appeals, they had a counter-argument, right?
They did. They didn't dispute the general idea of sovereign immunity. Instead, they said Congress already waived it in this specific context.
How? Where?
They pointed to another part of the Bankruptcy Code, Section 106A. This section explicitly says the government's sovereign immunity is waived with respect to a list of other Bankruptcy Code sections.
And Section 544, the clawback section we're talking about, is on that list.
It is. Section 544 is right there. So the lower courts read this waiver broadly. They figured that by waiving immunity for Section 544 claims, Congress must have intended to remove the immunity barrier for the whole process, including that underlying state law claim the trustee needs to invoke.
Basically, they thought the waiver cleaned the slate, fulfilling the actual creditor requirement, because now, hypothetically, that creditor could sue because immunity was waived by 106A.
That was the reasoning, yes. That the waiver wasn't just about if the court could hear the case, but also about what defenses the government could raise.
So that sets up the big question for the Supreme Court. This is really the heart of it, isn't it?
Absolutely. The core issue was, does that waiver in Section 106A just open the courthouse doors, give the court jurisdiction over the federal 544B claim?
Or does it go further and actually change the substance of the claim by knocking out the government's sovereign immunity defense as it applies to that embedded state law action?
Jurisdictional waiver versus a substantive one. That's the tightrope the court had to walk.
All right, so let's get to the decision. Section 3, the Supreme Court's ruling, how did it land?
It was an 8-1 decision. Justice Jackson wrote the opinion for the majority, and they reversed the 10th Circuit.
Meaning they sided with the government.
They did. The trustee's clawback attempt failed. That $145,000 stays with the U.S. Treasury.
Wow. So what was the core reasoning? How did they separate jurisdiction from substance?
The court held that the waiver in 106A only applies to the federal claim itself, the Section 544B action. It grants the bankruptcy court jurisdiction to hear that claim against the government. But it does not waive the government's immunity regarding the underlying state law fraudulent transfer claim, which is a necessary ingredient of the 544B claim.
So let me try and rephrase that. The federal law, 106A, lets the trustee sue the government under another federal law, 544B.
Yes.
But to win that 544B suit, the trustee needs to show an actual creditor could have won under state law. And since that actual creditor couldn't have won against the government because of immunity, the trustee can't win either.
That's exactly it. The court stressed that waivers of sovereign immunity are generally treated as purely jurisdictional. They allow a suit to proceed. They don't typically change the underlying rules of liability or create new rights against the government.
They don't create a winning claim where one didn't exist before.
Precisely. They're not meant to be liability creating. If the state law path was blocked by immunity outside of bankruptcy, it stays blocked inside bankruptcy, even when the trustee is the one suing under federal authority.
Did the court find support for this in the text of the law itself?
Yes. They pointed specifically to a part of the waiver statute, Section 106A5. It contains what some call the No New Claims Clause.
Okay, what did that say?
It explicitly states that nothing in the waiver section shall create any substantive claim for relief or cause of action not otherwise existing.
So the majority felt that reading the waiver to remove the state law immunity defense would effectively create a substantive claim against the government that didn't exist before bankruptcy.
Exactly. Under Utah law, standing alone, there was no viable claim against the feds because of immunity. The trustee's reading, they said, would improperly use the federal waiver to manufacture that missing state law viability.
And they also leaned on the general rule that waivers of sovereign immunity have to be interpreted narrowly, right?
Yes, that's a long-standing principle. Any ambiguity in a waiver statute is resolved in favor of the sovereign, in this case the government. No stretching the waiver beyond its clear terms.
So the bottom line is the trustee is stuck with the actual creditor's limitations if that creditor hits the sovereign immunity wall.
The trustee hits the same wall. The fraudulent nature of the transfer becomes almost irrelevant at that point because the designated path to recovery under 544B is blocked by this fundamental defense.
Okay, but this raises a big question. The trustee argued that if this is the ruling, doesn't it make Congress's decision to even list Section 544 in the waiver 106A kind of pointless, at least for 544B against the federal government?
That was a powerful argument. Why include 544 in the waiver if immunity still blocks recovery in these common fraudulent transfer scenarios? The court anticipated this and had a couple of answers.
What were they? How does the waiver still have meaning for Section 544?
First, they pointed out that Section 544 has two main parts, A and B. We've been focused on 544B, the actual creditor rule, but 544A, the strong-arm power, works differently.
How so?
Section 544A often deals with avoiding things like unperfected security interests or certain statutory liens like federal tax liens under specific circumstances. Crucially, 544A does not require the trustee to step into the shoes of an actual creditor.
So the waiver in 106A still allows trustees to use 544A powers against the federal government, for instance, to challenge a federal tax lien's priority.
Exactly. That power remains fully functional against the feds thanks to the 106A waiver because it doesn't have that problematic actual creditor component tied to state law immunity.
Okay, that's one reason the waiver isn't meaningless. What was the second?
The second involves state governments. Section 106A waives sovereign immunity not just for the federal government, but also for state and local governmental units in bankruptcy court. So imagine a similar fraudulent transfer, but the money went to a state agency instead of the IRS. Now, many states have waived their own sovereign immunity for certain types of claims under their own state laws.
Okay.
In that scenario, the trustee could use 544B. They could point to an actual creditor who could sue the state under state law because the state waived its own immunity. And the federal waiver in 106A would give the federal bankruptcy court jurisdiction to hear that 544B claim against the state.
I see. So the federal waiver still does important work for 544B claims against states that have their own waivers, even if it doesn't overcome the federal government's immunity shield in the Miller situation.
Correct. The issue was really the specific interplay of 544B's requirement and the very robust nature of federal sovereign immunity, which Congress hadn't waived broadly enough to cover the underlying state action.
Now let's quickly touch on the dissent. Justice Gorsuch was the lone dissenter here. What was his main objection?
His dissent really focused on what he saw as the majority, blurring the lines between a cause of action, the actual claim of fraudulent transfer, and an affirmative defense, which is what sovereign immunity is.
How did he separate those?
He argued that the substance of the claim, the elements of fraudulent transfer under Utah law, was clearly met. The company was insolvent, money was transferred for no value, etc. That cause of action existed.
Okay.
Sovereign immunity, in his view, isn't an element of the claim itself. It's a defense the government can choose to raise. And his argument was that Congress, through Section 106A, specifically chose to take that defense away from the government in the bankruptcy context for Section 544 claims.
So for Gorsuch, waiving the defense doesn't illegally create a claim. It just allows an existing valid claim to proceed without being blocked by that specific defense.
Exactly.
Yeah.
He felt the majority's reading effectively allowed the immunity defense to sneak back in through the actual creditor requirement, frustrating Congress's clear intent in 106A to make the government accountable in bankruptcy like other creditors, at least regarding Section 544.
A fundamental disagreement on how the waiver interacts with the underlying state law requirement.
A very fundamental one, yeah.
So wrapping this up, the final outcome is pretty stark for creditors in situations like this, despite what looks like clear fraud.
Yep, the $145,000 tax payment made with company money is effectively untouchable. It stays with the U.S. government because of sovereign immunity, as applied to the mechanics of Section 544B.
And this really narrows the path for bankruptcy trustees trying to recover funds for creditors when a federal agency happens to be the recipient, especially through fraudulent transfers tied to state law.
It absolutely does. It underscores that even slam-dunk evidence of financial misconduct might not be enough when you run up against a doctrine as powerful as sovereign immunity. The specific legal tool used, that actual creditor rule, was the weak link here.
But the court, or at least the reporting around the case, did sort of hint at another avenue, didn't it? Something the trustee didn't pursue here?
That's right. And it's a critical point for you, the listener, to think about strategically. While the trustee couldn't get the money back from the government, there was another potential target.
The shareholders, the individuals who actually orchestrated the fraudulent payment in the first place.
Exactly. They don't have sovereign immunity. They're the ones who benefited personally by having their taxes paid with company money. The trustee could have sued them directly to recover the funds for the bankruptcy estate.
So the big takeaway, perhaps, is that if the government holds the money and immunity blocks direct recovery.
The focus has to shift. Trustees might be forced to prioritize going after the individuals involved in the fraud, seeking a judgment against their personal assets to make the creditors whole, even if the money itself now sits untouchable in government coffers.
Which leaves us with a final thought for you. When you see a case like this, where money is clearly diverted improperly but ends up with the government, does the pursuit of justice for the creditors hit a dead end? Or should the legal system, and maybe public attention, pivot entirely to holding the individuals who committed the fraud personally accountable, making them pay back what they took, regardless of where the money ultimately landed?
Something to definitely mull over. It changes the calculus quite a bit.